I'm Susan Hutchison. I'm here with my law partner, Ray Foreman. We're here to talk to you about taking your case to trial. Most of our clients have never been in litigation before or even inside of a courtroom. And so the more that we can inform you about the process, the more comfortable you'll be.
Susan, I think there's a lot of lawyers that haven't been to trial.
Well, that may well be, but our focus is on making our clients feel comfortable and informed about the trial process. It's a long, sometimes a very long process before you get there, but the trial itself can also be a little scary if you don't know what's happening.
Why does it take so long?
Because our courts are so crowded that, and the litigants have to go through an entire discovery process where they have to exchange documents and take depositions and dealing with everyone's schedules. And then the court sets up a schedule, and it's usually about a 1 to 2 year schedule to get through all the pre-litigation before you get to trial.
Are there any other things that cause delays?
Well, there's all sorts of things that cause delays. You get dockets that get backed up. You get the parties that file motions. You dealing with everybody's schedules.
People get sick. The judge could get sick. The opposing counsel could get sick. We could get COVID for 2 years. I mean, there's a whole lot.
People go on vacations.
People go on vacations. You mean you can postpone the trial because of a vacation?
Well, that it happens. But we're here to talk about the trial process as opposed to getting to trial, right?
Yeah.
Okay.
That's
So
what we want to talk about.
is that what we're talking about?
Okay. I'm trying to get clear on it.
Well, when you want to talk about the pretrial?
No, I think we already did.
Okay. All right. Well, once you walk in the courtroom door, the courthouse door, and get in the courtroom, the first thing that's going to happen, if you've already addressed with the judge all of the issues that are evidentiary and witnesses, that kind of thing that could come up, first thing that's going to happen is picking a jury.
Well, I want you to pick a good one.
Well, in Texas, it's funny. You don't actually pick who you want to be on your jury. You unpick who you don't want to be on your jury.
And you don't have unlimited choices as to who to deselect. You only get 6 strikes on a 12-person jury and only 3 strikes on a 6-person jury. And so it's a bit of a misnomer about picking a jury. You can get rid of a few, but you're not going to get to pick your jury.
Right. And then after you get rid of a few, the ones you want to get rid of, and the other side gets rid of the ones they want to get rid of, the first 12 people that are sitting there, starting with the very first person and counting off to 12, that's the jury.
Right. And our clients need to get used to the idea that the 5 or 6 that they like the best, they're going to get struck by the defense.
Yes. And hopefully the 5 or 6 that the defense likes the best, hopefully those are the ones that we strike.
So we're going to get 12 people that nobody really likes.
That's true. That's true. And, the people that are kind of sitting up front, those are the most likely candidates to get on the jury. So those are the ones that you kind of need to keep an eye on. And we ask our clients to kind of pay attention and keep an eye on folks and have their own opinions, offer their own opinions about who might be good and who we might need to get rid of.
Well, after we pick the jury, first of all, clients ask me this question all the time, and I'm sure yours do. Do I have to come for all this?
Yes. Do I have to miss work for all this? Because trials are going to be, anywhere from 3 days to 2 weeks, depending on, how big the case is, how many witnesses are going to be called. And yes, the client has to be sitting there through the entire process. It's their case. It's their trial.
Well, that's the way Susan and I feel. There are other lawyers that only let their clients go to the trial during the time that they testify, but we're not those lawyers. We believe.
No, the jury's watching counsel table, and they're paying attention as to whether the client's sitting there or not. And if the client can't be bothered to sit through the whole trial, why should a jury be bothered to sit through the whole trial?
Yeah, we feel strongly about that. There are law firms that believe, they don't, if the client is severely injured, they don't want to put the client through having to sit through the trial because of the discomfort and the pain. But as far as I know, in the 33 years and Susan and I have been practicing, our clients sat through the entire trial with us.
There might be exceptions. I don't know, but there haven't been any
We
so
haven't had
far.
one yet.
Right. And we hope and expect our clients to be as invested in the process as we are.
Right.
So after the jury is seated in the jury box, the lawyers do opening statements. So you got one lawyer on your side that's going to get up and do an opening statement. Then the lawyer on the other side is going to get up and do an opening statement to tell the jury what the case is about. And once the opening statements are done, we start calling our witnesses and we ask them questions, introduce evidence, introduce documents as exhibits that the court's going to let in. And then when we're done asking questions, the other side gets to cross-examine that witness.
Now, you say we call our witnesses. Often Susan and I call witnesses that are actually employed by the defendant or witnesses of the defense, but we get a chance to call those in our case in chief. Now, they may be adverse witnesses, and you may say, well, why in the world would you call somebody who's against us in your case in chief? And the reason is we want to get out ahead of whatever their testimony is going to be. And we also want to frame their testimony in a way that's supportive of our case and maybe deconstructs their case.
Right. And we very, very strongly believe that the jury is interested in credibility. They're interested in who's the truth tellers. We want to be the truth tellers, which means we want the jury to believe that we're ready to put everything out there. So we call their witnesses to show, hey, we're not afraid of this. This is part of the story. This is part of what happened. We're truth tellers. We're going to put this evidence on, no matter what it is.
And we feel strongly about that because in our years of experience, we have seen the benefits of practicing law this way. So it seems a little counterproductive. The worst witness for us in the case may be the first witness we call, and often it is.
That's true. But it is really, really important to us to tell the truth to the jury. Yeah. That's the good, the bad, and the ugly. And
all of the truth, not just a part of it.
Right. The whole story. And then, and they're going to edit that part out. And after the witnesses, our side is done calling witnesses and putting evidence on, then there's usually a little break where the jury gets dismissed and the other side makes a motion. They make legal motions, asking the judge to throw the case out, etc. That gets overruled and the jury comes back in, and then it's the other side's turn to call any witnesses that they want to call that we haven't called. And then we get to cross-examine those witnesses.
Why does it take so long?
What, the trial?
Yeah. You said about a week, maybe longer. You said even sometimes 3 weeks.
Well, it could be several weeks. Usually our cases get tried in a week, but we've been in trials where it lasts longer. Just kind of depends on how many witnesses you have. That's going to be the main driving force, is how many witnesses are going to be called. Because if you've got 10 witnesses, and each side asks them questions and introduces documents, it's a process.
Yeah, and if the witnesses are just average witnesses of average length, Susan and I find that you can't really call more than about 2 in a day, maybe 3 at the most. So, for example, if we have the witness on direct for an hour, they get to take a break and then they get to cross, and maybe they cross for 45 minutes and then we redirect for 15 minutes. There's 2 hours for that one witness. So, and that's a pretty short witness. So you're not going to get more than 2 or 3 witnesses on per day, generally. Sometimes they're longer, sometimes they're shorter, but it just takes a while.
It does take a while. Once all of the evidence is in, then the jury once again gets sent away, and the parties talk about what questions are going to be given to the jury. It's called the charge. So the court decides, the lawyers argue, and the court decides, how are these questions going to go to the jury? How are they going to be asked? What instructions they're going to include? And then once the court gets the charge, bring the jury back in, and the lawyers do closing arguments. After closing arguments, the court gives the jury the charge, which are the questions they're supposed to answer. For example, the jury find that John Smith was fired because of race discrimination? Yes or no? And so they have a series of questions to answer like that. If they answer yes, then they are asked to decide how much money John Smith gets as a result. If they answer no, then the case is over.
Clients always ask me, how much money can the jury give and how much are we asking for?
Well, the jury can give any amount the jury believes is reasonable. There are caps in different types of cases. So if it's an employment case or a med mal case in Texas, there are caps. And no matter what the jury awards, we can only get the amount of the caps. That's it, regardless of what the jury awards.
So if we get a $4 million verdict from the jury, you mean that the legislature takes that away from our clients and only gives them the amount of the cap?
Yes.
Well,
That's exactly how that works.
How's that legal?
Take that up with the legislature. It's part of the tort reform process where all the tort reformists, which are mainly insurance companies and defense lawyers, decided that people were getting too much money from juries, even though that's the system we have, and that's what we've always relied upon is the jury system.
I think it's a travesty that we trust a jury to decide who can be put to death by the death penalty, but we don't trust them to tell you how much the value of a baby's worth.
It's because it's about money.
Well, it's terrible, but that's what our clients need to understand. That's the system that they voted for and they elected officials have imposed on us here in Texas. They don't have caps in Oklahoma and New Mexico because they held that they're unconstitutional, but in Texas we do.
Right. So we tell the jury the amount of money that we are asking them for, but it's up to the jury to decide completely at their own discretion as to what numbers to put in the blanks.
Can people lie in court?
Of course, people lie. In every case we have, somebody's lying. In every single case we have, somebody's lying. Otherwise, we wouldn't be in court. So somebody's not telling the truth. It's up to the jury to decide who that is.
Why didn't the judge do something to them people that are lying?
Well, because the judge doesn't make the decision as to who's lying. The jury makes the decision as to who's lying.
Well, how come they don't go to jail?
Because in every single case we have, somebody's lying. So you're talking about, hundreds of thousands of cases where somebody's lying. So, that's just not feasible. People don't go to jail. People think that, if I tell a lie in court, that's perjury. That's a crime. Well, that's true, but there's not anybody going to do anything about it.
But the jury does do something about it. The jury finds in favor of the side that they believe to be most trustworthy and credible, and that's why you get a verdict. And so the jury in a civil case, the only thing they can do, they can't send anybody to jail. The version of justice that they hand out is civil justice, which means they value and they put a value on the amount of the loss or damage that the plaintiff has suffered.
And that's justice.
Do I have to wear a suit?
You have to dress in your good church clothes. You don't necessarily have to wear a suit.
Church, so that's not a very good guide.
All right. No, you don't have to wear a suit. But
Can I wear flip flops and a mini skirt?
You have to dress appropriately for court, which means you have to wear, your shirt has to have a collar. You can't wear any skirts that are too short, anything that's too revealing. You just have to dress appropriately for court.
Not like you're going out on a date and trying to attract somebody.
No.
Very conservatively. What about my jewelry and my Rolex and my diamonds and my earrings?
Right. Leave all the expensive jewelry at home.
Why?
Because the jury is assessing you and evaluating you, and you're telling them that you are in financial need as a result of this terrible thing that's happened to you. And if you wear your expensive jewelry and your Rolex to court, you're sending the jury the wrong message.
Tim, we need to cut out the jewelry thing. I'm sorry I brought that up.
Okay.
All right. Now, how do we wrap it up?
That's a good question. How do we wrap it
After
up?
we get the verdict, when do they pay you the next day, or when do they write you a check?
Well, depends on whether they appeal or not, because as long as it took to get to trial, if they decide to appeal it, it could be another 3 years after the verdict.
Well, it already took us 2.5 years to get here.
Right. We've had cases that we still have that have been up on appeal and back down again, that we're trying to get to trial, and it's been 8 years.
Yeah, Waffle House was 7 years, and we got a case at the Fifth Circuit right now. It's already been 7 years. Justice moves slow through our system.
It definitely moves slow. Now, one thing that the question I always get is, well, if we go to trial, we can't settle anymore, right? And the answer to that is,
you can settle it anytime you want to if you got an offer and you're willing to take it.
We've settled cases in the middle. We had one case where Rafe was in the middle of cross-examining a witness in the middle of trial. Yeah. And the other side asked for a break, went out in the hall, and offered us additional money, and we settled the case right in the middle of the trial.
Yeah.
So it can happen at any time from the moment you hire us until, the last appeal is over. The case can be settled at any time.
If we win a verdict, though, they have to pay us, right?
Not if they appeal it.
What about if they file bankruptcy?
Or if they file bankruptcy, or if there's caps to be applied, or, those are the exceptions I can think of.
Yeah, me too. We've only had a couple of cases where they filed bankruptcy, but we've had more than we can tell you about cases that were appealed and drug on for additional years. What about if we get reversed on appeal? Then what happens?
It depends. If the Court of Appeals can say, oh, I think something wrong happened at trial. Maybe the judge admitted evidence that the judge shouldn't have admitted, or something like that. And they can reverse the jury's verdict, send it back to the trial court, and make us try the case all over again.
And that's the best case scenario, because if they reverse and render, that means you don't get another trial, you just lose.
Yeah, they can say, well, we think that the plaintiff should never have won in the first place, and so therefore we're reversing the verdict and the plaintiff gets nada. So there's all kinds of things that can happen on appeal. And if we've won at the trial court, the things that can happen on appeal, none of them are good. So,
yeah, it's like swimming in the ocean. 3 things can happen and all of them are bad.
Yeah. Unless, of course, if we win on appeal, that's it, we win. And then we get to collect the verdict.
Do we get paid interest on a verdict?
We get post-judgment interest, and sometimes pre-judgment interest if there aren't any caps.
Okay. Who pays all the cost?
The loser, which means that if we lose, our clients are liable for the other side's costs.
You mean if I'm a client, you mean I can sue them for firing me illegally and I lose and they can make me pay their costs?
Yes.
Well, that don't seem right.
Losing side pays.
That's a tough pill to swallow. So you got to know that going in.
Absolutely. And I'm glad you raised that issue, but I think we've pretty much covered taking your case to trial. But if you have any questions, give us a call or shoot us an email.
If you have any questions, please watch this video again.
Anything else you want to add?
No, we need to think of an ending.
Well, that was the ending.
No, we need to think of an ending that's consistent that we end all of our videos with. We don't have to come up with it now, but like if you have a medical emergency, call 911. If you need information, call 411. But if you got a legal emergency, you call 4911.